everyone, this is Devika Sharma, and this week in the 29th episode of SCC Online Weekly Rewind, amongst the number of stories that I bring you, I have picked two very interesting ones to keep you clued in. So stay with me as I will also be announcing the winner of SCC Online Quiz. In a very interesting issue, Federal Court of Australia became the first judicial authority to recognize AI machines as inventors of patents. The decision centered around the question whether artificial intelligence systems can be an inventor for the purposes of the Patent Act, to which the court asked that if the output of an artificial intelligence system is said to be the invention, who is the inventor? And if the human is required, who? The programmer, the owner, the operator, the trainer, the person who provided input data, all of these or none of these. Court expressed that in some cases it may be none of these. In some cases, the better analysis is to say that the system itself is the inventor. That would reflect the reality and you would avoid otherwise uncertainty. And indeed, that may be the case if the unit embodying the artificial intelligence has its own autonomy. What if it is free to trawl the internet to obtain its own input or training data? What about a robot operating independently in a public space, having its own senses, learning from the environment and making its own decisions? And what about the more exotic, such as a mobile unit on Mars left to its own devices and not seeking instructions from Earth? Justice Beach, in light of these observations, stated that we are both created and create. Why cannot our own creations also create? Thus, in this remarkable decision, court, while noting that the name of the inventor can be non-human, held that DABUS and AI can be an inventor. Another very interesting case came from National Consumer Disputes Redressal Commission. Have you ever gone to a salon and something unfortunate like a haircut you wished for went all wrong, accompanying a bad hair treatment leading to a burnt scalp? Well, a salon at ITC Maurya became responsible for causing this to a model who came in for the haircut right before a week of her interview. In its striking decision, NCDRC, while expressing that women are emotionally attached to their hair, granted ₹2 crores compensation, as she was not only given wrong haircut but in fact was also subjected to medical negligence. To read my report on this really interesting and remarkable decision, go to SCC Online blog. Now let's move on to the Supreme Court updates. In a case where a man was convicted for killing his wife under suspicion of her infidelity and was sentenced to undergo rigorous imprisonment for life, Supreme Court has refused to go into the question of propriety of specifying rigorous imprisonment while imposing life sentence and has held that imprisonment for life is equivalent to rigorous imprisonment for life. In an interesting case, the Supreme Court has succinctly declared that a caretaker or servant can never acquire interest in the property irrespective of his long possession, and the caretaker or servant has to be given possession forthwith on demand. Sexual violence knows no boundaries. It occurs in every country across all parts of the society. The Bombay High Court, while noting a case of sexual harassment caused to a child aged 17 years, due to which she took the step of ending her life, rejected the bail of the accused. In this horrendous incident, the miserable fact was that this young girl was hesitant to disclose the ill intentions of the accused, who was her own uncle. In a note scribed by the deceased, she had opened her mind to her mother, wherein she spoke about her uncle's ill deed and also offered an explanation as to why she concealed it from her mother. She expressed her helplessness. She suffered the consequences mutely for a year. Hearing this harrowing incident, the High Court penned down that a child may be subjected to sexual abuse or exploitation at home too. Unfortunately, we have not been able to create an atmosphere in the society where parents, teachers, and adults in company of the child can identify signs of abuse and make sure children received care and protection. Reiterating the well-settled position that contractual employees are not the employees of the principal employer, the Bombay High Court held that contractual employees are engaged through contractors. Their service conditions are governed by the contracts between them. Hence, in case of any grievance, they shall approach the contractor and not a principal employer. Court also observed that these employees work with the principal employer through contractor only during the contract period. After the contract period is over, their contractor may enter into a contract with another establishment and shift them to work there. From that view of the matter also, they cannot be treated like permanent employees of the principal employer, and therefore they cannot claim voting rights at par with the permanent employees. Can DNA tests be conducted to determine legitimacy of a child in a divorce petition? The Kerala High Court answered this question when it recently held that it would be permissible for a court to direct the holding of a DNA examination to determine the veracity of the allegations constituting the grounds for divorce if a strong prima facie case is made out. Observing that when a man abandons his wife and children, roving vultures wait to prey on not only the abandoned women but also the helpless children. Kerala High Court noted horrendous act of a temple priest who took an abandoned woman and her 3 children under his wing and repeatedly molested the elder girl child in the presence of her siblings. Expressing anguish, the court said, "We wonder which God would accept the obeisance and offerings of such priest or make him a medium." Upholding his conviction for rape, the High Court awarded the maximum sentence of life imprisonment to the priest. Emphasizing on the gravity of seriousness of Section 307 of the Penal Code, the Delhi High Court observed that an offence under Section 307 ITC will fall under the category of heinous offence and therefore has to be treated as a crime against the society and not against the individual alone. And the proceedings under Section 307 IPC cannot be quashed only on the ground that the parties have resolved the entire disputes among themselves. Since in this case, the victim was stabbed with a dangerous weapon, that is a knife, and the injuries caused were of such nature that they would have caused death in ordinary circumstances, the Delhi High Court declined to quash the criminal proceedings. Asserting that deity in the temple is a minor and the court should be astute to protect the interests of an idol in any litigation, the Madras High Court held that when the trustee or the executive officer or the custodian of the idol, temple and its properties leave the same in lurch, any person interested in respect of such temple or worshipping deity can certainly be clothed with an ad hoc power or representation to protect its interests. Now moving on to a foreign court judgment. While issuing a permanent injunction stating Apple could no longer prohibit developers linking to their own purchasing mechanisms, the United States District Court for the North District of California held that Epic Games failed to show how Apple Inc. was operating an illegal monopoly. Epic Games Inc. sued Apple Inc. alleging violations of federal and state antitrust laws and California's unfair competition laws based upon Apple's operation of its App Store. Trial did show that Apple was engaging in anti-competitive conduct under California's competition laws. Further, the court concluded that Apple's anti-steering provisions hide critical information from consumers and illegally stifle consumer choice. Since Apple has created an ecosystem with interlocking rules and regulations, it is difficult to evaluate any specific restriction in isolation or in a vacuum. Thus, looking at the combination of the challenged restrictions and Apple's justifications and the lack thereof, the court found that common threads run through Apple's practices which unreasonably restrains competition and harm consumers, namely the lack of information and transparency about policies that affect consumers' ability to find cheaper prices, increased customer service, and options regarding their purchases. Apple employs these policies so that it can extract supra-competitive commissions from this highly lucrative gaming industry. Apple Inc. and its officers, agents, servants, employees, and any person in active concern or participation with them were permanently restrained and enjoined from prohibiting developers from including their apps and their metadata buttons, external links, or other calls to action that direct customers to purchasing mechanisms in addition to in-app purchasing, and communicating with customers through points of contact obtained voluntarily from customers through account registration within the app. By now, you must have come across the decision centered around the dispute with regard to Maruti Suzuki versus its dealers. And in case you have not, I have got you covered. The Competition Commission of India has imposed a penalty of Rs 200 crores on Maruti Suzuki India Limited on finding that Maruti Suzuki used to impose penalties on its dealers for violating its discount control policy. The CCI held that Maruti Suzuki India Limited was not a third party in the enforcement of the discount control mechanism as claimed by it, but a significant player such as MSIL imposes minimum selling price restrictions in the form of maximum discount that can be offered by the dealers. Resale price management can decrease the pricing pressure on competing manufacturers. The backdrop of this case was that the dealers were discouraged from giving extra discounts, freebies, etc. to consumers beyond what was permitted by MSIL. If found to be violating the discount control policy, the dealers were threatened with imposition of penalty not only upon the dealership but also upon its individual persons, including direct sales executive, regional manager, showroom manager, team leader, etc., and stopping of supplies. To know the detailed story on why Rs 200 crore penalty was imposed, check out my report on SCC online blog. Let's begin with the legislation updates. The Central Board of Indirect Taxes and Customs has notified the Electronic Duty Credit Ledger Regulations 2021. The regulations provide for: first, issuance of duty credit in the scroll; second, creation of e-script; third, registration and validity of e-script; fourth, suspension or cancellation of duty credit. The Government of Goa has extended the last date for clearing the dues and water charges for all domestic and non-domestic water consumers under the Dues Recovery and Settlement Scheme 2020-2021 till October 31, 2021. Wide notification dated September 16, 2021. The scheme applies to those water consumers who have defaulted on dues up to 31st October 2020. The defaulting water consumers whose cases are referred to Revenue Recovery Court as on October 31st, 2020, those water consumers whose installations are either temporarily or permanently disconnected as on October 31st, 2020. The Insurance Regulatory and Development Authority of India has issued extension of timelines for issuance of electronic policies and dispensing with physical signatures till March 31st, 2022. Read the complete list of circular on SCC online blog. The Central Board of Direct Taxes has issued a notification that no deduction of tax shall be made on the following payment under Section 194A of the Income Tax Act 1961, which specifies interest other than interest on securities made by a scheduled bank located in a specified area to a member of scheduled tribe residing in any specified area as referred to in clause 26 of section 10 of the Income Tax Act, subject to specified conditions. Read a full story on SCC online to know the specified conditions. So let's come to the most interesting part of the weekly rewind that everyone has been waiting for. In this week's SCC online quiz, we had asked how many 9-judge bench judgments are reported on SCC online web edition and which was the first one. The answer is 19 judgments, and the first one was in reference to C Customs Act. And the winner for this week's quiz is Ayan Gupta. Congratulations to you. Thank you everyone. This is Devika Sharma signing off for this week.